Good morning. Welcome to the Law News Network. I'm Jesse Weber. Thanks for joining us. All right, I'm going to give you a rundown about what we're handling today. We have two big cases that we're going to be talking about today. First, we're continuing our coverage of the Morris twins trial. Now, if you've been following this is the trial of Boston Celtics forward Marcus Morris and his brother Washington Wizards forward Markieff Morris. Now, they've been charged with 2 counts of aggravated assault, which are a felony in Arizona. The brothers are accused of beating up Erick outside of a Phoenix gym in January of 2015, and they face up to 4 years in prison if they're found guilty. At the time of this alleged attack, the Morris twins were teammates on the Phoenix Suns, and I gotta tell you, I used to be a big fan of this team, so it's not great to see how everything's turning out now. But let's talk a little bit about this case. According to a police report, the victim, Erick, said he and another woman had been watching a youth basketball game at a recreation center, and when he walked out, someone hit him from behind. The hit caused Hood to fall to the ground. He tried to run to his car, but was stopped and attacked by 5 men, including, allegedly, the Morris twins. Now, Hood said he suffered a fractured nose and abrasions as a result of the attack. He took the stand a few days ago. Law enforcement officials believe the attack was premeditated and a retaliation for Hood texting an inappropriate message to the mother of the Morris twins. Well, 2 of the other co-defendants in this case, they've pleaded guilty to the same charges, but the Morris twins and the final defendant in this case, Gerald Bowman, they've pled not guilty. So now the Morris twins say they not only had nothing to do with the attack, in fact claiming that they were in the parking lot at least 100 yards away from the incident, but that they have no previous ties to Hood. The defense is claiming that the victim, along with other witnesses who are testifying in this trial, are pointing the finger at the Morris twins for money, that they want to get money out of them. So the defense has even pointed to inconsistencies in witness statements, and one of the other men that's been accused in this attack, the defense says he's changed his story multiple times. If convicted, this is the nitty-gritty of this. If convicted, as I said, the Morris twins would not only face possible jail time, but due to their collective bargaining agreement with the NBA, they would face a 10-game suspension. We're going to have a sports law analyst on later, a sports law attorney, to talk a little bit about that collective bargaining agreement. What does that mean for their future, and what does that mean for the profession in general? So as we continue our coverage of this trial later today, we'll have analysis, but we're going to talk a little bit today in the beginning before we start that coverage. One of the other cases that we're going to be handling today is a breaking development. This is the case of Brendan Dassey. I know a lot of you know, where do I know that name from? Well, you should, because this is the case out of Wisconsin. Brendan Dassey, who was one of the subjects of the widely popular Netflix program Making a Murderer. He was sentenced to life in prison in 2007 for the death of photographer Teresa Halbach. He was 16 when he told detectives that he helped his uncle, Stephen Avery, rape and kill Halbach in the Avery family junkyard. Today, a federal appeals court will consider arguments over whether detectives use coercive and unconstitutional police tactics to trick Dassey into confessing, and whether now he should be released from jail and go free. Previously, a federal magistrate judge overturned Dassey's conviction last year, ruling that detectives did take advantage of Dassey's youth and his cognitive disabilities to coerce his confession, and this past June, a 3-judge panel from the appellate court upheld this ruling. So now we're going to be seeing the counter-arguments in this appeal, what is going to happen, and there's much to discuss. There's constant legal issues in this case. It captured the nation by storm. When people watched that video in the Making the Murderer, they watched his confession, many people thought it was coerced. They thought it was improper. They thought that he was taken advantage of and shouldn't have been released free. On the other side, this is a man who is convicted of a brutal crime, and many say he should not be released. So here to help me talk a little bit more about this case is someone who handled this case, who was reporting on it from the scene when it was occurring all those years back, LawNewz's own Erin Keller.
Jesse,
Erin,
good to see you.
Great to see you. As I said, you were nitty-gritty in this whole case as it was going on. I have many questions to talk to you about because this is a big day. Just let's step back and talk from just a procedural aspect. We're going to be hearing some oral arguments today. This is Law News. Can you explain to our viewers a little bit about what that might look like from this panel?
Okay, so this case has jumped through about 15 different hoops at this point. We had the trial, okay, which resulted in a conviction by a jury in Wisconsin back in 2007, if I have my years correctly, when I was working as a loss for Brendan Dassey. Then it started to go through a federal appeals process. It went through the district court, then up to the Seventh Circuit Court of Appeals, and the Seventh Circuit affirmed the lower district court and basically said yes, that this confession should go out the window. So, in essence, that Dassey should be released. Well, the state isn't going to let him go that easily because the state is still convinced that he played a role in this crime. So now we're listening today for the Seventh Circuit Court of Appeals to have its full, what's called an en banc argument. Basically, it just means every single judge on the court hears this case instead of just the 3 judges who heard it before. So it went from the federal district court to the Seventh Circuit. Now it's still in the Seventh Circuit, but all of the judges are hearing the case. If you go and read the original Seventh Circuit opinion on the 3-judge panel, which came out a couple of months ago, it's really a split opinion. 2 of the judges believed that it should result in Brendan Dassey being freed, that the way that the police did the interrogation just wasn't up to snuff. But there's a really strong dissent, and the question is just how many minds are we going to count up to this time? Is it going to go in Brendan Dassey's favor, or is it not? The judges are having a 30-minute oral argument at 10:30 Central Time, 11:30 Eastern. We can't carry it live because the Seventh Circuit is not one of the circuit courts that has, at this point, decided to do live audio streams, but they do release audio of the argument usually later on the same day. So when those audio recordings come out, we're hoping, depending on what time they release them, to play them later this afternoon on LawNewz.
I know. I wish we did have a live feed to that. That would have been great. But yeah, like you said, we might have an audio version. If we do, we're going to let our viewers know where they can listen to it because it's really not going to miss it. And from a legal perspective, there's so many issues to tackle with this case. I want to get into the nitty-gritty of it. I really want to talk about the million-dollar question. Was Brendan Dassey's, in your opinion, his confession coerced? And I want to, before I ask you that, I'm going to read to you the statement from the magistrate judge who originally overturned the conviction, and then I'm just going to briefly tell you what the 3-judge panel said. So this is the statement before we get into it. From the magistrate judge. The state courts unreasonably found that the Dassey's confession was involuntary. The state courts unreasonably found that the investigators never made Dassey any promises during the March 1st, 2006 interrogation, saying that didn't make sense. The investigators repeatedly claimed to already know what happened on October 31st and assured Dassey that he had nothing to worry about. These repeated false promises, when considered in conjunction with all relevant factors, most especially Dassey's age, his intellectual deficits, and the absence of a supportive adult, rendered Dassey's confession involuntary under the 5th and 14th Amendments. The Wisconsin Court of Appeals decision to the contrary was an unreasonable application of a clearly established federal law. And then later on, the 3-judge panel who affirmed this decision, they found also that this confession was coerced by investigators and that false promises were made, and this was a violation of his rights. Erin, after reading that statement and what you know, what are your opinions about this confession?
Well, look, I mean, there's a couple different ways to look at the confession, and a lot of people have looked at the recording at this point. Here's the thing. First of all, when we were covering this case, we did not have access to the recording of the full purported confession. I mean, some people don't even think it was a confession, but I'll call it the confession just to make the conversation simple, while I'm still recognizing the argument that some people don't think it was a confession. Some people think he was spoon-fed. So just to call it the confession recording, we didn't have access to it, to the full recording, until after the case had already wrapped up. And this is one of these things in open records law in most states. If something is bound for litigation, it's exempt from a state open records law. And the upshot of it is that when we're covering the case as journalists, the only thing we had to go on was the special prosecutor getting up there and saying, well, there is a confession. Well, at face value, That sounds pretty damaging. Here's the thing. When parts of the confession, and again, parts of it, were played in open court, here's the thing. There's two different ways to take it. One way to watch that recording is to say that he's a young kid with borderline intellectual capabilities and without the benefit of a parent or without the benefit of an attorney present. And one way to look at it is to say that, yes, he was just repeating back what the investigators spoon-fed him. Another way to look at it, which is the way the jury looked at it, is to say that he was someone who had been pressured by his family to lie about what he knew and who somewhere in there told the truth. Now, I wasn't in the courtroom when the clips of the recording were played, but my colleagues who were said that the jury changed in tone immediately during the original trial, and that the jury took a look at those recordings, and after that, the body language of the jury just completely changed. They completely shut down. They didn't even want to look at the defendant. If they did, it was just a very different tone in the courtroom. So the way the jury took what they heard was to assume that he had played a role in this. Now, I suppose that begs the next question: how much of a role might he have played? And this is one of the arguments that Dassey's appellate attorneys have been getting into on the appeal is, well, some parts of this might not make sense based on the evidence. You know, we've heard the age-old argument time and time again for the last 10 years or more that, well, why isn't her DNA present in his trailer? And a lot of people try to use that as a reason to say that, well, the crime must not have happened the way Brendan Dassey claimed in the so-called confession. Well, the absence of DNA doesn't necessarily indicate that it didn't happen that way, but it makes the state's case a lot harder. So a lot of this boils down to just how that jury wanted to characterize that recording.
Right.
And, ultimately the appeals court is trying to go through the law and figure out, well, what it should be. But the standard in the state's mind is pretty well set, and the state followed it in the state's argument. The state directly accused the appeals court, the previous court, and the magistrate judge at the district court level of completely rewriting federal law when it comes to confessions like this. And that's concerning in and of itself.
Yeah, Erin, let's talk about that a little bit, because the state is saying that you're going to be upending long-established police tactics. And the argument that they would make is juvenile confessions have been upheld in cases involving far more police pressure. And if you look at this case, they read him his Miranda rights. They asked his mother to talk to him. They told him not to make anything up. They used open-ended questions that resulted in him providing most of the details of this incident. And he admitted to the rape, the murder, and the mutilation within the first hour of the interview. Those are their best arguments moving forward. And if the state should lose, doesn't this set some sort of precedent for that circuit and for confessions, juvenile confessions throughout the nation? I'm reading this, I see this, and this is one side, and we'll get into the other one, but the idea that they did something improper doesn't seem so clear on its face.
Well, look, the devil's in the details on this. And again, the problem is that the confession recording can be viewed a couple of different ways. And, people who want to look at it as a false confession are going to find plenty of evidence in there to back up that belief. People who want to look at it as a true blue confession can look at it another way and point to a few things and say, hey, look, the kid was trying to lie. He, eventually told the truth after a lot of prodding from investigators. Now, there's a side issue going on here, and this one gets even more difficult to unravel. First of all, they read him his Miranda rights 20 million times, and he waived them every single time. So he could have, in theory, shut this whole thing down.
Now, did he understand them is the question. Did he understand them?
I don't know if the case has necessarily been appealed on that premise. The Miranda waiver was deemed valid, if I'm remembering this properly, quite some time ago. So the issue isn't the Miranda. The issue is the nature of the questioning itself. Mm-hmm. I don't think that the appeals courts and I have looked at the actual voluntariness of the Miranda waiver in a long time. they took a lot of time to walk him through that. So,
right, it adds a context to,
and again,
to their further
just
interrogation.
It gets into this back and forth as to whether or not, what do we believe? It may be, and people who think he's guilty would look at it and say, the reason that he waived it and didn't want his mother present is because the rest of the family was pressuring him to say certain things. I don't know. And that's what I keep going back to with this. The reason we keep talking about the case is because there are two sides to it that have strong, colorable arguments.
Right. The eerie nature of this whole case, and I mean, anybody that wants to see it can watch it, but like you said, it's because we have so many unresolved questions, and there's been a lot of history with the Avery family in that community, and it provided for some very interesting drama for people to watch. But what's interesting, Erin, is we're seeing one case out of a million in this country where you have juveniles that are charged with crimes and they can confess, and it'd be interesting to see. We're only really watching this one. What happens in other cases where it's videotaped and it doesn't strike the public at large and we don't get a chance to view it? What happened in those confessions? Is it similar? Is it different? We don't know because we're only looking at this one.
Well, I'd be more afraid about the ones that aren't recorded, because keep in mind, in Wisconsin, this was one of the first cases where an interrogation of a juvenile was recorded because of a newly enacted state law which required the recording. So if we didn't have the recording, we probably wouldn't even be sitting here talking about this to the degree that we are. We probably would have either an audio tape or some kind of other transcript. We might not even have that. So I'd be more worried about the states that don't have the recordings.
It's a good
because
point.
We don't know what's going on there.
Let's talk a little bit about some of the statements that were made by police. The idea that they said, let's get it all out today and then it's over. Or then they said, the truth will set you free. I'm not a cop right now. These kind of statements, people have been saying, well, are these false promises? Are these blatant lies? What are your opinion about that?
Well, it sounds to get eerily similar to the so-called Christian burial case that you and I both studied in law school, where there's a line at which, when police officers try to cross it, then the confession gets thrown out by the courts because it sounds just too sneaky to pass the ordinary smell test. If they're sitting there saying, oh, we're not police officers, we're here to help you. Well, Jesse, you and I both know that if you're going to make a deal as a defendant, you have to deal with the prosecutor, not the police. The police can take the things that you say and use them against you. The prosecutor is the only one in the courtroom that can make the deal. Mm-hmm. So, again, if he had counsel present, the counsel probably would have shut that interview down right then and there. But because he waived the right to an attorney for the interrogation, the floodgates opened up, and then you had this sort of sneaky interrogation tactic being played out. And look, I mean, I don't necessarily know if I blame the two who handled the interrogation. I think they were trying to do the job that they were trained to do. The question is, should we allow it to happen, and should there be some new standard coming out of this based on the newer social science research?
Erin, why has Dassey remained in prison pending these appeals?
Well, they tried to get him out. His attorneys, Steve Drizzen and Laura Nyrider, have tried to extract him out, but every time they try, because he's won basically both of the federal hearings that he's had, the state files some kind of an emergency notice or something to keep him incarcerated pending the next jump up the appeals ladder. So, the fact that the Seventh Circuit went and did an en banc hearing where all of the judges will sit and hear the case is legally extremely rare. Seventh Circuit doesn't do these very often. The circuit courts don't do them very often as a threshold. The Seventh Circuit doesn't do them very much at all. It's more likely that the U.S. Supreme Court will take your case than the Seventh Circuit will give you an en banc hearing. But in this case, a lot of people are sitting there saying, oh, it probably won't go to en banc. He's probably going to, because here's the thing, if the Seventh Circuit didn't take the en banc hearing, then the state would have either had to let him go or go to the U.S. Supreme Court. And if the U.S. Supreme Court said no, then he would have gone free at that point, because that was the last decision in his favor. So, a lot of people are thinking, oh, the Seventh Circuit won't take it, the U.S. Supreme Court won't take it, he'll go free. I was sitting there saying, I don't know, this legal issue is novel enough, and look, we recognize this 10 years ago when we were covering the case. This legal issue is novel enough where I could see the U.S. Supreme Court taking this case, because there is law on the matter, but it's a little nebulous. It's not been very clearly defined on the contours, and a lot of interrogators are probably sitting there looking at this case saying, okay, what's permissible and what's not?
Right, and they might need that standard moving forward.
Here. You know, if we're going to adopt what the courts would call a prophylactic rule and say, if there's somebody under a certain age, bottom line, they have to have a parent present or they have to have an attorney present, no ifs, ands, or buts, well, you know, maybe we're at a point as a society where we need that.
You know, Erin, you moved into the next part of what I wanted to ask, is that even if the Seventh Circuit upholds these lower court rulings and they throw out his confessions, it's possible it could go up to the Supreme Court. Now, let's just talk a little bit about that. Everybody assumes they know the structure of how our government, our system works. You make an appeal, the Supreme Court, the highest court of the land, but it's not so simple taking an appeal there. And doesn't it matter also how many judges would rule in favor of the you know, in terms of the outcome of this decision? For example, if you have a majority ruling, for example, how many judges would rule in favor of this? Doesn't that also determine whether or not the Supreme Court would take the case? Expand a little bit more about how easily it is for this to go up to the Supreme Court. You mentioned it's a novel issue, and I agree with you. I think we do need some cohesion and some clarity on this subject, but that might not be the whole thing. Am I correct?
You're correct, but I'd be hard-pressed to answer exactly what the math has to be. I mean, the state, surely, if it loses, will petition for a writ of certiorari to go to the U.S. Supreme Court. It's a question as to whether or not enough justices on the U.S. Supreme Court agree to take the case. It's novel enough where, in theory, it could happen, and I feel guilty even saying that it could, because you and I both know that, you know, for every million cases out there, one or two of them get to the U.S. Supreme Court. But you know, it depends on what the Seventh Circuit does with the en banc hearing as well. You know, if it's a tight decision, then, you know, I could see the Supreme Court potentially taking a really strong look at it. You know, the question is, where is this going to go? It was 2-1 in favor of Brendan Dassey. Maybe the judge who issued the dissent in the first panel is going to be the lone holdout, and every other judge agrees that he should go free. Mm-hmm. Well, if it's a really strong hearing at the circuit court level, you know, that might be enough of a resounding clarification of the law for it not to go any further.
Right. And again, if the Supreme Court, if he's successful in the Seventh Circuit Court of Appeals, the Supreme Court doesn't take up the case, he's going free. He's going free, and it puts an end to a long saga. I mean, again, there's two sides to this story. People can't forget that there is the Teresa Halbach family who are listening to this, following this case, have been dealing with this tragedy for over 10 years. So there's a lot of different players involved, a lot of different stakes. Again, we are talking about Brendan Dassey here, the subject of Making a Murderer, one of the subjects of the Making the Murderer Netflix program, who arguments will be heard today in the Seventh Circuit Court of Appeals about whether or not his confession to police was coerced and whether or not he should be released. Erin, I want to switch gears a little bit. I want to talk a little bit about the Morris brothers. We've been following that on here on the LawNewz Network. Been a fascinating case about aggravated assault in Arizona. I'm going to show in a little bit the clip of the victim testifying, which is, you know, it's something we don't get to see a lot here, because on a lot of the times the trials we cover here on LawNewz Network, they're brutal, brutal murders. And here, luckily, it was only an assault, but we heard the victim testify, and we're going to play you some of that. I want to just get your initial impressions about this case. I mean, the defense is putting out there that this is only put forward. They're only pointing the finger at the state is only pointing the finger at the at the Morris twins because of money, that this victim and his friends wanted money. You've been following this case. What are your initial impressions of the case and of that argument?
Well, it's an interesting argument. And look, I mean, the lawyering in this case has been excellent. Both sides have been right on their A game. The judge has been phenomenally good with evidence rulings. The case is being tried in a very fair and very even-handed fashion. The defense, at first, when the defense started to needle at some of these people about text messages and statements, at first I thought it was sort of a weird way to get into the argument. But the more I hear it, the more it's becoming concerning because, it's one thing for somebody who's a witness to sort of send a text message and joke about, oh, I witnessed this attack involving a couple of NBA players. I might be in some money. I mean, it's an off-color joke. It's not really appropriate, but I could see an argument where the person was just playing around, to sort of release the tension of the situation. In other words, it would be believable that the attack happened, but for this thing sort of coloring the witness's opinion in sort of a funky way. But, yesterday, I think the tables turned because there was discussion yesterday that one of the eyewitnesses was actually asked to lie about what he had seen in return for some kind of a settlement payout. So, well, now you're talking about witness tampering, and, the witness is like, well, that's what I was asked, yes, but I didn't do it. I'm not up here lying. I'm telling you the truth about what I saw. Well, the fact that it even went that far, that really colors things in a different shade.
Yeah, that's one way of putting it.
I think that the defense is making a point. I'm still waiting for some of the other witnesses to come out. And this case has been moving very slowly because there are 3 defendants on trial. Each one has an attorney, and each one is trying to point the finger at each of the other ones. So I guess a lot of it might really boil down to whether or not the 2 who pled out, who were also part of this, who admitted they were part of it, whether they're going to get on the stand and say, yes, these NBA players were a part of it with me. That I don't know if that's going to happen, but I'm waiting to see if it is.
Yeah, well, we're going to turn right now to the testimony of Erick Hood, but Erin, it's so funny isn't it possible, isn't it just plausible that this could be a situation where a guy was unfortunately beat up by a lot of different guys, and in this whole mix, he's looking around, he's dazed, he's confused, he sees the Morris twins out there and might have thought maybe they were a part of the attack. It makes sense, but they were, I think they claimed 100 yards away. It's possible that in this kind of crazy incident, confusion results, and maybe there is no nefarious motive, but maybe it's just a mistake. Isn't that possible?
I mean, it's possible. I think that you should be a defense attorney now, Jesse. What are you doing sitting at LawNewz? You should be down in Phoenix defending the Morris twins. I mean, that's
I like reporting on it too much. What can I say?
So, but ultimately that's the argument. I think that there's also some evidence that maybe one of the twins might have been more involved than the other, but nobody's quite sure which one because, they are identical twins. They and it's not like I said this yesterday. One's not a PhD chemist and the other one's a basketball player. They're both basketball players. They have similar physiques. They have similar workout routines.
They're both forwards of 2 basketball teams. They're both in the same position.
They play the same exact position.
Right.
How many people have families where one person gets into professional sports, let alone 2? A lot of the witnesses are like, well, one was standing near me and the other was up there, and I'm not sure which one it was. Well, is that enough for reasonable doubt? I don't know.
And Erin, let's not forget, I don't know what they were wearing at the time of the crime, but they were both teammates on the Phoenix Suns. Isn't it plausible that they could have been wearing the same outfits, same kind of off-court gear? It's possible.
And questions have been asked about that, and I can't right off the tip of my tongue remember the answers to them, but I think that there's been some confusion about that. So look, the defense is doing a great job of sowing the seeds of reasonable doubt in this case. And, some of the motives of the victim and some of the other witnesses saying that, oh, well, we were talking about splitting up money, we were talking about a settlement, that went on. And then this other nugget came down late last evening when I was there, sitting in the chair that you're occupying right now. But there's this. The defense did a good job, I think, of attacking the investigatory skills of the lead detective on the case. And that's pretty hard to do. But, one of the accusations is that this whole thing started with some kind of text message from the victim, Erick Hood, to the Morris brothers' mother. Well, one of the questions the defense had of the detective is, where's the text message? Where's the subpoena to the cell phone company? Have you seen it? And the answer is, I didn't even subpoena the cell phone company to see if the message existed.
Right.
Well, if the state's trying to prove its case that message was a motive for the attack, I think that that's a pretty serious investigatory lapse that, somehow needs to be cleared up. But, again, at the end of the day, everybody's pointing the finger at these twins saying they were both involved. So you've got eyewitnesses saying they were involved.
Yeah. Let me say this, as you said, Aaron, if they can't find that text message, that will be really hurt their case, the prosecution's case against the defense. But I will tell you this much, okay, not to make light of the situation. You don't text someone's mother. That causes problems, okay? That is a big motive right there. So, okay, I understand. They want to go with a motive, it works.
I mean, I haven't, but it's given me a new idea of how to play practical jokes on you, Jesse.
Well, let's see what happens. Easy now. Easy now. Watch yourself. All right, Aaron, thank you so much. Aaron, I don't know if we're going to still have you on, but I do want to still have more questions about the Morris twins trial. We are going to show, a clip of Erick Hood testifying in the case. Hopefully we have Erin Keller on with us to discuss a little bit more. But in the meantime, take a look at Erick Hood's testimony in the Morris brothers trial.
What happened towards the end of the game in terms of what you call, you ever see that group of individuals go to 5? You ever see them leave, get up? Tell me what you remember.
I remember, like maybe 50 seconds left on the clock. Marcus and Keith left the gym. They were all sitting up at the top. And then the other 3 guys, when they walked out the gym, the other 3 guys sat on the bottom row.
And you say Spears, as you were there, with the images paper that you were staying on that side there.
Yeah, I didn't look.
As the basketball game ends, what happens?
I hung around the gym for as long as I could. And I heard earlier in openings that it was...
I want to ask you about... I want you to just answer the question.
Okay. I want to say I stayed in the gym for maybe 30 minutes.
Okay.
At least.
What about Miss Sherrod? Did she stay with you?
Yes.
And as the game was over, did any of those 5 remain that you saw in the gym waiting for you inside the gym?
Yes.
Who did you see in there waiting?
Julius and the other 2 guys.
How long did they wait? Did they walk out of the gym with you?
No. It was, they turned the lights out. The guy who works in the gym, or whoever it was, pretty much turned the lights out. Told everybody that was remaining in the gym that we had to leave. So that's when I started to exit the gymnasium.
Let's talk about that. So you're walking out of the gymnasium. What is the first thing you remember in terms of walking out of the gym?
When I walked out, I want to say it was 2 sets of double doors. And so I walked out the first set, and then as soon as I walked out of the second set of doors, I saw Julius Kane with a t-shirt on, and in the gym he had on a sweater. So he was kind of like laid up against the wall, and he had his arms crossed, and excuse my language, but he said, "Hey, Muffer, you know what time it is." So I turn and look at him and say, "What are you talking about?" And as soon as he said that, I got hit.
Take a picture. Do you need the projector again? Ladies and gentlemen, I'm going to turn the lights back on.
So you indicated that you walked out and he said, I think you paraphrased it, "I want to try and talk about as best you can recall the specifics of that night." So can you tell us what it was that you were doing when you walked out of the gym?
Yes. Excuse my language. He said, "Motherfucker, you know what time it is."
And where is Teresa Sherrod as this is going?
We were walking side by side.
Do you say anything back to Julius Kane?
Yes, I said, "What you talking about?"
And then after you responded, I think you said this earlier, is that when you were struck?
Yes.
Is that the extent of
That's it.
So you said you were struck. Were you seen with you?
I don't know who hit me.
You know where you got hit from?
I got hit on the left side, back of my head.
And what did you do once you got hit?
I took off.
Now, it's fair to say that this event caught you off guard or surprised you like that. I mean, ask it a better way. Were you expecting to get hit right there when you got hit?
No, I was expecting to square off with the guy that confronted me.
Now, once you got hit in the back of the head, you said you took off running. Can you describe the direction and where it was you ran?
I started to run towards my vehicle.
Welcome back to Law News Network. I'm Jesse Weber. You're watching the prior testimony of the victim, Erick Hood, in the Morris brothers trial out of Arizona. Again, this is the trial of Boston Celtics forward Marcus Morris and his brother Washington Wizards forward Markieff Morris. They have both been charged with 2 counts of aggravated assault, which is a felony in Arizona. The brothers are accused of beating up Mr. Hood outside of a Phoenix gym in January of 2015, and they face up to 4 years in prison if they're found guilty, as well as potential suspension, a 10-game suspension if they are convicted. Here to help me talk a little bit about this case is someone who's been following this case is our Law News' own Erin Keller. Erin and I were talking a little bit about the Morris twins trial as well as Brendan Dassey, because there's an update in that case with a hearing today, a court hearing, oral arguments going to be made in that case to determine whether or not Brendan Dassey's confession was coerced and if he should be released from jail. But we are focusing on the Morris twins trial here today. Erin, you were just watching the victim, Erick Hood, testifying. General question before we talk a little bit about his testimony. What do you make of victims testifying on the stand? It's something, as I said, we don't have the luxury of seeing because we do cover some very brutal crimes where the victim is deceased, but now we have someone who can recount what actually happened to him or to the best of his knowledge. But what do you make of victims taking the stand?
Well, look, I mean, there is no better witness, right, in most cases. Sometimes they can't remember everything because of the severity of the attack, but having a victim on the stand helps the jury understand, look, something serious happened here. It's serious enough for we, the members of the jury, to give up parts of our lives to come here and try to settle the dispute. So it's critical. I mean, ultimately, he's the key witness, the guy who says, I was attacked and these are the ones who did it. And the reason I know these are the ones who did it was because of this prior dispute about this email. Again, keep in mind here that the victim knew the attackers to some degree. There are pictures of them together going back quite some time. The victim does some sort of sports management. He's not really an agent, but he's involved in the athletic community. It's part of the reason why he was at this particular event. So it's critical to have a victim on the stand as a witness. Look at the War Machine case that we covered 6 or so months ago on Law News. Christy Mack, she made the whole case. Yep. She's the one that got up there and said, look, this guy brutally attacked me. She was credible. She was believable. And look, the defense tried to attack some of her background a little bit, just as we saw the defense try to attack Erick Hood's background a little bit here. But again, why have the victim on the stand? This is why. It's the jury's job to weigh the facts in a case like this. The jury has to look the victim in the eye, sit next to the victim, and figure out, using the same skills that we all use in everyday life, whether or not that witness, that victim witness, is telling the truth or fudging the facts. That's the jury's job, is to sit there and study the body language, the tone, the demeanor, the words used, the eye contact, whether or not the witness is confident, whether the witness is trembling, and why, if that's the case. So in this case, because there's the accusation from the defense that that guy we just heard is really just making half of this up to shake down the Morris brothers for $7 million because he said he would accept a settlement of no less than $7 million. All he really had was a couple of scratches and a broken nose. That's a lot of money for a broken nose. I think that he's kind of overstating his civil case here by many millions of dollars. So, ultimately the jury's going to have to weigh whether or not they believed what that guy was saying on the stand.
He was charged with, they were charged with aggravated assault, and one aspect of that was temporary disfigurement. That is because I'm assuming the nose, the crush of the nose, but was that pushing it a little much?
Well, they're going to charge what they think they can get, Jesse. And so, look, temporary disfigurement, broken nose. If the charge fits, the jury has to decide whether the charge sticks.
Yeah, I want to turn to what you just said a minute ago about the fact that they know each other, because as you said that they have photographs together, and he was involved in sports management, he was in that industry, but the defense is saying they had no ties to the victim here, Erick Hood, that the Morris twins didn't really know him or have ties to it. How's a jury supposed to reconcile those two arguments?
Well, I would hope that somebody's going to put the pictures up that we have at LawNewz and that have been shown on the screen, if I'm not mistaken, at least once, that show the groups of them together.
Yeah.
So, okay, look, maybe they didn't know him well. Maybe it was just like a fan picture, and if you're a professional athlete, you have thousands of people asking to have their photo taken with you. Maybe that's all it is, but the bottom line is, look, there's a picture of them together. Right. They were at the same game together. These folks seem to have been crossing paths in some way, and I do think the defense sort of oversold its case a little bit in saying, there's really not a connection. Well, there's some connection. The better argument is that it's not a strong connection. They met in passing, and the twins don't even remember it, maybe. Mm-hmm. But I don't know. Again, there's some of the cell phone evidence the police didn't even dig into, so we don't know how deep the connections go beneath the surface.
Let's turn a little bit more to Erick Hood's testimony. We're continuing that because the reason I want to turn to it is one of the arguments, or one of the things that Erin and I discussed was a victim who is in such a chaotic event, he's being beat up. Is his recollection of what he saw and heard accurate? I want to turn to the continuation of Erick Hood's testimony, and Erin and I will talk a little bit about that as we delve into further testimony in this case, because we will be having live coverage later on today of this case. But now is the time to analyze what we've seen and what we've heard. And remember, not just what we've seen and heard, but what the jurors have seen and heard and what they're trying to think about and make of this case as they continue on in the next day. So right now, let's continue on with our coverage and let's look a little bit more at Erick Hood's testimony.
At the point in which you get hit, that you're running to the parking lot, what happens after that?
I'm gone. I'm running down the street.
What made you stop from running to your car, make the decision to run down the street?
I just didn't think that I would make it.
Do you have any idea at the point in which you were running, whether it was towards your car running down the street, how many people were facing? I was running. Eventually, you make your way down toward the bottom part of that exhibit, exhibit 1. Is that right?
Yes.
That street down there.
Yes.
Yes, sir.
At some point, do the individuals that are chasing you,
Yes, sir.
describe what happened, what leads to how them laying hands on you down by the end of the street, how that all unfolded.
I was running, I was sprinting. I didn't slip on no rock or anything like that. I just want to say that my momentum, it's kind of like, I was running fast. As you can see, it was a very, very long distance for me to get to that door down there. And pretty much I was running for my life. I was scared. And, my momentum just carried me, and I fell.
Now, once you fall to the ground, what happens?
I started to get attacked. I started to get pummeled.
Okay. Are you lying down on the ground when this occurred?
Yes.
Do you have any idea how many individuals at that point are around you?
Yeah, 5.
Let's describe a little bit about, as best you can recall, once you fall to the ground, is it all 5 descend on you and then time how that all played out? Is one of them grab you first? I want to hear the details that you can recall about what happened.
And it was, the most terrifying moment in my life. So I fell. Remember Julius hold me on the ground. And as I was trying to get up, just kept saying, "Mook, you trying to get up? Mook, you trying to get up?" And then that's when I saw Marcus come over and kick me relentlessly. Kid Bowman, at that time, had on some boots, and I was kind of laying on my side here, and the guy, he just jumped straight up and landed on me, 2 feet. It was a flurry, it seemed like it lasts forever to me. I don't know how long it took. I don't know how long, I was getting attacked. Then next thing I know, I wake up and
So what's the next thing you remember about that?
waking up and trying to gather myself together to stand up.
And when you wake up, are the guys who have been assaulting you, are they still there?
No.
All right. When you wake up, who's there?
Sharika and 2 other gentlemen.
Now, when you took off running prior to falling down at the end of the street, where did Sharika go?
I don't know. I didn't see her. And I feel bad, because
He wasn't running with you.
no.
And let me ask you this, based on the encounter at the door and then what you physically experienced, did you interpret that the individuals who confronted you were intending to target you or her?
Did I relay that to her?
No, I'm saying you would, in terms of what was said to you at the door and then everything you interpreted, did you get the feeling that whoever those guys were and whatever they wanted to do, they were going to do it?
Yes, sir.
So, from the time you run away from that entrance where you had been standing by her to the street, you don't know where she went until next you wake up.
Yeah, with her car.
You indicated that at some point during the attack when you fell down on the ground down the end of the street, that you would have came to hold it down and said something. What it was you said.
He just kept saying, "Mook, he trying to get up. Mook, he trying to get up."
Do you have any idea who looked at?
Yes,
Who was that?
that's Marcus.
What is that, a name of Marcus?
Yes, sir.
And you've known that nickname college, high school?
Since high school.
So you knew, based on what Julius was saying, that the person he was calling for was associated with specifically Marcus. Is that right?
Yeah, and it wasn't even just what he said, is what I saw as well.
And I was going to go to that next. So after you heard that statement, Mookie's trying to get up, Mookie's trying to get up, you indicated you saw an individual coming to you.
Yes, sir.
You identified that individual as Marcus Morris.
Yes, sir. Where did he kick you? Where didn't he kick you?
Let me ask you this, you kicked you in the head.
Yes.
What are you doing as you are getting kicked in front of
I'm trying to survive. I'm balled up. I'm trying not to get hit. I want to say when they stopped, I kind of opened myself up to play dead. And to play dead, you got to be still. So that's what I did. And next thing you know, I'm waking up.
I thought that was
Welcome back to Law News Network. I'm Jesse Weber. You're watching the Erick Hood testimony in the Morris Brothers trial out of Arizona. And here to help me talk about it all this morning is LawNewz's own Erin Keller. Erin, we were watching Erick Hood testify, and as we talked about, this is now we're getting into the crucial bit of his testimony where he's talking about that event. And as we said, one of the things he talked about is I was being hit. I didn't know what was happening, which is understandable for somebody who was in that event. Obviously, he was attacked and injured. But this is a point when the defense could go on the offensive and say, you were discombobulated. You didn't know what was going on. You didn't know what you saw, what you heard. And as we said earlier, you might have seen the Morris brothers 100 yards away. Doesn't necessarily mean that they were the attackers. Your thoughts on that?
Well, in essence, that's more or less what the defense did. I don't have their exact lines memorized right at the moment, but that's part of the game that they played. Some of it had to do with the perception, but a lot more of it had to do with, let's say, if the Morris brothers were involved, which one of them was involved, because they look so much alike that a lot of witnesses are saying, yeah, well, one of them was up closer to the attack than the other one, I'm not sure which one it was. Is that enough to sow some reasonable doubt into this? That's a question that the jury's going to have to try to reconcile.
Yeah. Just to give a recap for our viewers, this is the Morris brothers trial. This is the trial of Boston Celtics forward Marcus Morris and his brother Washington Wizards forward Markieff Morris. They've both been charged with 2 counts of aggravated assault felony in Arizona. The brothers are accused of beating up Erick Hood, who you just watched testifying, outside of a Phoenix gym in January of 2015, and they face up to 4 years in prison if found guilty. But that's not it. That's not the big crucial part. I mean, it is. But another big part about this, because they are sports stars and what we are going to talk about later on today, is the fact about their collective bargaining agreements with the NBA. Because according to these agreements, if they are convicted, they can face a 10-game suspension. But to talk a little bit more about how that process works, what does that mean, and what does this mean for the sport in general, and how those collective bargaining agreements work, we actually have a sports law attorney on with us later today in about an hour. And you're not going to want to miss this, because these are athletes, these are stars, these are people everybody knows. And being convicted of a crime for them doesn't just mean jail time. It means a really big hit to their career, their endorsements, the money they receive. That is really important for this case, and we're going to talk about that a little later on today. But as I was saying, I'm here with Erin Keller. We're talking about the legal implications of this case, and as we continue on with our focus on the Erick Hood testimony, Erin, explain a little bit more, because we're about to go into it, the idea of that money, the idea that the defense is saying, okay, you went after our clients because of money. And again, there was a civil suit that was filed by Erick Hood. So please just explain to our viewers, elaborate a little bit more about this money aspect in terms of this attack.
In essence, it's not the whole defense, but it's most of the defense. So here's the thing. There's a criminal case and a civil case, and oftentimes the facts and the testimony that come out in the criminal case, if it leads to a conviction, just allow for a civil case that becomes not completely a rubber stamp, but more or less a rubber stamp of the criminal case. Because the criminal burden of proof is beyond a reasonable doubt, the civil burden of proof is lower. So if there's a criminal conviction, it's a foregone conclusion that there's going to be a civil judgment in the favor of the plaintiff, in this case, the victim. So here, the victim and his friend and apparently some of the other witnesses were thinking about looking at this thing, or at least were posed the possibility that this thing could just be a windfall payoff. Hey, look, if you want to say that these NBA players were involved, then the victim, Erick, said accept nothing less than a $7 million payoff for getting beaten up and getting a broken nose. I mean, that's an astronomical figure. I don't even know if he would win that in a civil case.
Mm-hmm. Yeah, I mean,
well, the dollar value attached to the injury is commensurate with the injury. You know, I mean, so pain and suffering for a broken nose is not the same thing as pain and suffering if somebody severs their spine in a car accident. It's a different standard. The guy, there was no weapon used. He's up walking around after a brief hospital treatment. He's talking. He's walking. He's back engaged in life. He's able to work, and so the damages would be nowhere near $7 million in a civil judgment. But this victim seems to think he's going to be able to shake the Morris brothers down.
But isn't that just so convenient for any celebrity, any person with wealth who's charged with a crime? The defense, you can say, is, well, they're only going after them because of money. Isn't that just, you, as a defense attorney, you'd have to make that argument? Whether or not the jury believes it is one thing, but, you know, you have to make that argument because your client is technically a target. Now, whether or not that's true, that's for the jury to decide, but don't you have to make that argument?
It's not an unwise argument, but I think you have to make the argument when there is evidence on the record that it's exactly what might be happening, which is what we have in this case. There are text messages between the victim and the friend that took him to the hospital, between the friend and another friend, and statements made by the victim himself. You know, this came out of the victim's own mouth. It came out of the friend who took him to the hospital's mouth. It sounds like collusion. And it came out of the mouths of one of the witnesses that, hey, I was promised a payout if I make this case easy. You have to bring it up for sure when you have that kind of evidence in your favor. So I don't fault the defense in any way for bringing it up in this case. In another case where there is no clear-cut evidence that it might be going on, well, maybe it would sort of be a tactic to sort of wink, wink, nudge, nudge, say something like this is going on. But, I mean, look, Jesse, you know from tort class in law school that plaintiffs are going to go where there's deep pockets. So,
of course,
you know,
absolutely.
That's not, I mean, and the premise isn't necessarily a sleazy one. It's, for instance, if, you're a multi-million-dollar corporation, you invite people onto your premises, but you don't clean up the produce aisle and somebody slips and falls, then there's a judgment. You know, there's an idea, at least in law, that in such a situation like that, almost anyone has almost an equal chance of being harmed by a product or sometimes a situation. And I know I'm crisscrossing products liability with slip and fall tort law.
How
which I
dare
shouldn't
you?
do.
How dare you?
But, you know what I'm talking about. Right. So, that's one thing, to have a legal premise that if someone is allowed legally to reap enormous profits, then there needs to be an element of public protection rolled up into personal injury law. But when you have a celebrity defendant like this in a criminal courtroom, and there's this insinuation that people are lying in the criminal courtroom to sort of help this other civil case that's on the back burner in the background, and there are clear text messages to back up the theory. Look, I said before, the lawyering in this case has been excellent all the way around. The evidence objections have been excellent. The judge has been right on the money. If somebody tries to get into an area that they shouldn't be getting into, there's an objection right away. The judge makes a very quick ruling, and they move on. There's not hemming and hawing. There's not bad evidence getting in front of the jury. There aren't crazy theories getting in front of the jury, but if there's something on the record to support it, it is getting in front of the jury.
Yep, you said it. You said it perfectly. Let's tackle that issue of the money, and as you said, with those deep pockets, that is the defense that is being put forth by the defense, that their clients were victims, that their clients were the target of this attack. And when I say attack, I mean filing that lawsuit and all these accusations, because as you said, when you have the reward, the payoff is worth more than actually filing litigation, that's when you see people actually engaging in a trial. But let's turn a little bit more to that Erick Hood testimony, because we are going to go into that question of money, this key issue of money. So let's continue our coverage and show this testimony, and we'll be back more here with more analysis.
Police department. The police inquired about obtaining images from your phone. Is that correct?
Excuse me, not necessarily images, but just pretty much a text transcript between me and Miss Angel.
Okay. And as part of that, you turned over your phone to police to be analyzed. Is that a correct statement?
Yes, because I had nothing to hide. Yes, I turned my phone over to the police department.
And is it a fair characterization from you that you turned it over thinking they were looking for just text messages, but in fact what they did was a complete phone theft on your phone? Is that fair?
Yes, I had a signed document stating that they were taking a text from January 24 to a certain time to January 25th to a certain time. I had signed the document. I actually went to...
Your Honor, that was a yes or no question.
Christine?
So
Yes.
the moral of this is you expressed willingness to give the detectives your phone to look at some text messages that day, correct?
Yes, no problem.
And as an end result of this, ultimately, the contents of your phone around this time period, the entirety of your phone, was, I don't want to use the word dump, but it was released in terms of in the police records. They had everything. It wasn't just what you thought it was more than that. Is that a fair characterization?
Yes, sir.
Okay. So I wanted to ask you, and we've talked and we've showed some screen images of the text with Ms. Thomasine a couple of hours ago when we were talking about this. But the question before we got into all this cell phone discussion was, did you talk to your family members and friends after this incident in the weeks following the attack?
No.
Okay. Did you ever, to your recollection, mention the fact via text, whether with friends or family, that the Morris brothers were involved in this case?
No.
Okay. If I can approach the witness, Judge.
Yes.
Mr. Hood, I'm approaching with Exhibit 185. And I want you to look through this for a little bit and tell me if you know what that is.
This looked like text messages.
Okay. And what was well, let me ask you this without just pronouncing it out. Is your phone number one of these numbers listed on here at the time?
Yes.
Okay. So you believe these to be fair and accurate depictions of some of the texts you had going, and some of these dates include January 26th, so 2 days after the event, or February 11th, 2 days after the event?
Yes.
Okay. Now,
May, just the number of the exhibit.
185.
Thanks.
Now, do you recall telling anyone that you were going to make the twins pay for what they did?
Yes.
Okay, you do recall doing that.
Yes.
And was that in the weeks after the assault that you said that things like that?
Yes.
It is true that, well, and I'll ask you, these text messages, if they were to depict conversations in February or late February, these were weeks after you had already given statements to police about what had occurred that day, correct?
Yes.
And I don't want to, well, I'll ask you this question. As part of the purpose of saying you wanted the twins to pay, would you want them to be held responsible for their case?
Absolutely.
And that was responsible for what you thought their actions were on the 24th?
And what I know their actions were on the 24th.
It is true, Mr. Hood, is it not, that there is a civil suit pending regarding this incident, is that correct?
Yes.
And that is a suit that you have filed, correct?
Yes, with
Objection.
advice of my counsel.
Just,
Objection, it was a yes or no question. It goes beyond the scope of the question. It's just-
Disdain?
Yes.
That civil suit is pending.
Yes, sir.
And as part of the reason, and I don't want to get into anything that is between you and your attorney, I'm not asking questions about that, but as part of the reason why you did that, the same reason you already elicited or already stated, that you wanted them to be held responsible for what they did. Objection, meeting, Your Honor.
Disdain? Rephrase, please.
Why did you, let me ask it in a way that, why did you feel the need to file a civil suit?
Because I wanted them to talk.
Okay. Is part of the reason why you filed a civil suit because you were given advice by attorneys?
Yes. Which happened a year later, year and a half, actually, after I got attacked.
So that was going to be my last question on this line of questioning. When did you file a civil suit?
I was advised by counsel. Honestly, I don't know the exact date. They brought it to my attention, asked me how did I feel about it.
Let me ask you this, Mr. not to cut you off. Was it within 2 weeks of this incident that you filed a civil suit? Was it within a year of this incident that you filed a civil suit?
No.
So it was over a year later,
Yes, sir.
after you had talked with detectives numerous times about your version of the events that occurred that day?
Yes.
Welcome back to Law News Network. I'm Jesse Weber. Thanks for joining us. We are talking about two big legal cases today. First, you were watching the testimony of Erick Hood in the Morris brothers trial out of Arizona. Again, this is the trial of Boston Celtics forward Marcus Morris and his brother Washington Wizards forward Keith Morris, who have both been charged with 2 counts of aggravated assault felonies in Arizona. They're accused of beating up Erick Hood, who was just testifying there outside of a Phoenix gym in January of 2015. They face prison time and possible game suspension, 10-game suspension if they are found convicted, if they are found guilty. We're also talking about today Brendan Dassey. Again, this is the subject of the Making the Murderer Netflix series, which many of you have probably watched and know the face very well. He was sentenced to life in prison in 2007 in the death of photographer Teresa Hallback. He was 16 when he told detectives that he helped his uncle, Stephen Avery, rape and kill Hallback at the Avery family junkyard. Today, a federal appeals court, the 7th Circuit, will consider arguments over whether or not Dassey's confession to police was coerced and whether or not he should be released from prison. That is the case. That is what we were talking about. And helping me to talk about both of these issues is LawNewz's own Erin Keller. Erin, I want to talk a little bit more about Morris Brothers because we, as I said, there's a lot to talk about with this victim, Erick Hood. But, and also for our viewers, just to let you know, we're taking questions. Erin and I are taking questions about both Morris Brothers and Brendan Dassey. So go on the chat room, ask us a question, and we'll make sure to talk about it. One of the questions we've actually got was about that civil suit that that Erick Hood had filed against the Morris brothers. There was a question about when he filed it. According to what we just heard in his testimony, it was about a year and a half after the attack. Does that date mean anything to you in the fact that he didn't file that civil suit 2 weeks after? He didn't file it within a year. He filed it sometime later. Now, obviously there's something to be said about understanding your options and weighing the pros and cons of litigation. But a year and a half? What do you make of that?
Well, if it's within the statute of limitations, then it flies. If anything, it bodes well for the victim and the state, because if the state could argue that were the victim really out for money, he would have been breaking down the courthouse door as soon as he was physically able to file the suit and try to shake these twins down for whatever they're worth. But that's not what happened. There was a 1.5 year wait. And if I were prosecuting the case, I would argue, hey, look, this theory that the defense has that this is all about money just doesn't bear out when you look at the facts. If the victim were really out for money, he would have been filing immediately, not a 1.5 years later.
Yeah, I agree. I think it is actually not what the defense wanted to hear. And this big issue, this issue of money, this issue of the Morris brothers have targets on the back, that's the big defense going here. So I agree. The idea that it was filed sometime later bodes well for the state in this case. We're going to continue our coverage here of this case, but I am curious about the other testimony that we saw. Besides the victim here, Erick Hood, which we're going to show more of that. We had talked a little bit earlier in the break about the testimony of a police officer who got on the stand. Talking a little bit about that, you said it didn't bode well for the state in this case. I'm curious what your thoughts are on that.
Well, a couple of different things here. First of all, the detective, the lead detective on the case, admitted that this text message, which has been insinuated as being the point behind the attack, the motive, was not discovered by the police. They didn't serve a subpoena on the cell phone company to get evidence that it had occurred. So, well, whoops, that to me is a pretty glaring hole in the investigation. Maybe the reason the police didn't go that way is because they just turned around and said, well, we think we've got enough for a conviction. Let's launch the ship and see which way the winds take us. But if that's one of the elements of motive, which they may not have to prove, I'd have to dig into the law a little bit more. My guess is that they just didn't think that they needed it, but it did give the defense room to attack the investigation. That's one thing. Some of the rest of it just sounded like the defense was attacking the police department for being overzealous with this investigation. They were trying to say, well, all of these managers got involved. You were given an unlimited checkbook. You had all the time in the world to work on it. This is the first case in your several decade career where you were told in the very beginning that you have all the time and all the resources in the world to throw into this thing. Well, that makes it sound like the Phoenix Police Department is trying to pick on the Morris brothers because of who they are. Mm-hmm. That's what the defense is trying to argue, but it's sort of an interesting tactic for the defense to say that the police department is both being zealous. In other words, they're investigating a case too much and they're investigating it not enough. It's sort of an interesting dichotomy here, and I can't say as though I've heard such an argument before, at least that I can remember. But that's what they're saying. See, you investigated it too much, but not enough.
You can't win. You can't win.
Yeah, exactly. And look, I mean, a police department knows when they're going after somebody who's got a lot of money, who can throw a lot of their own resources into an investigation. My guess is that there probably was nothing nefarious about it, that the police just said, look, we've got witnesses who say that these two are involved. We know it's going to be a tough case to prosecute. We're going to have to put as much money into it as possible so that everyone is held equal under the same law. We just know we're going to be in for a fight on this one. Now, the lack of the text messages bothering me, or the phone call or whatever it was between the victim and the mother that was alleged to be the reason for this attack, that does bother me. But some of the rest of the stuff, I'm hoping the jury just says, well, seriously, if I were running a police department and I had to go after a couple of NBA players, I would sure want my ducks in a row as well.
Well, you'd hope so, at least. You'd hope so, at least. Listen, at the end of the day, the jurors are the triers of fact. They have to sort through all the testimony, all the witness statements, all of the evidence, not only to determine what happened, make a story. Remember, for a jury, they're not seeing what we see. We can read articles about it. We can talk about it. They're not watching LawNewz and hearing what our analysis of it is. They are only getting what's in that trial. So they have to understand what happened, the story, the players, and whether or not they can believe any of the evidence or testimony. It's not an easy job, but that's what they're going to have to determine. And as you said, part of that is the investigation and the tactics that were taken. Speaking of investigation and tactics, we have a bunch of questions on our message board about Brendan Dassey. So we're going to switch over now to Brendan Dassey. Erin, a couple of questions about this case. So the first one is, if Brendan's successful in his appeal, and again, we're going to hear oral arguments today in the Seventh Circuit about that confession. Was there unconstitutional tactics used, and whether or not he should be released from prison? If he wins his appeal, can that help Steven Avery in his case?
I don't think that it would directly. I mean, it might be some moral support to the Avery family, but I don't see the Brendan Dassey case as being in any way connected to the Avery case, because Brendan didn't testify against Steven at trial. The issue with the two cases was more, in my opinion, that the special prosecutor kind of spilled the beans in the press conference that was stitched together based on Dassey's so-called confession, and that sort of on the back end, through the back door, poisoned the case against Avery. That, though, is something that I don't see Brendan Dassey's possible exoneration being attached to the current appeal that Steven Avery has lodged.
And a lot of people are talking about this confession. Obviously, that's the main issue here, whether or not this will set him free. One of the questions we have are about juvenile protection laws, and Erin and I don't specialize in this. I don't know if you know that much about it, but the question is, how does that affect confessions from kids, minors? Do those kind of laws differ in terms of whether or not you can throw out confessions that maybe are coerced, or is there a different standard for minors? I mean, one of the issues in this case was Brendan Dassey's age as well as his mental capabilities, but your thoughts on juvenile protection laws and police interrogation tactics?
Well, it would seem to me that we should be having exactly the conversation we're having. The people that decide it right now are sitting on the Seventh Circuit Court of Appeals, and they're going to start hearing the case in about 13 minutes. So, look, it would seem to me, just as a personal opinion, that children are still at a state where they either look up to or are afraid of the authority of police officers, and they might be inclined to sort of go along with a law enforcement interrogation tactic. I can see, and this is the thing, I see the case that Brendan has. It's a colorable argument. The law, from what I know right now, is just a little too nebulous. We don't have a clear enough standard, and that's why this case has gone up so many hoops through the appeals court, has jumped through this many appeals court hoops, because it might be the case that sets the standard after it being a little too loosey-goosey. So, look, hopefully that answers the question, but, should Brendan Dassey have been interrogated that way? Maybe, maybe not. Again, it depends on how you read it, but I'm not the one that ultimately has to make the opinion on it, so I try not to, if that makes sense. I can see both sides and try to represent the arguments, because, again, there's two sides to the story. One side is that he went along with the investigators because he was afraid, or he thought he was going to get a deal or something, and told them what they wanted to hear, and that the confession therefore isn't valid. That's one side of it. The other side of it is that he was lying because he had been pressured to lie by his family. And look, I was there for a lot of this, and I was in the midst of a lot of these people. I can see that being a possible argument. And that finally, through good police techniques, he was worn down to the point where he did tell the truth finally somewhere in there. Those are the two sides of it, and how the law works to deal with juvenile confessions is going to depend on how many people sitting on that court agree with whichever version of this actually happened. So in my gut read, though, if people were appointing me the king of the world, I probably would want some stronger protections in place. But what those look like, I don't know. Maybe it just means that a parent has to be there for the Miranda.
Mm-hmm. Well,
maybe
no,
it's not just the juvenile who needs to sign the Miranda, but the parent.
Yeah.
And again, what's the exception? That what if the juvenile is being asked about a crime the parent committed? I mean, there are so many different versions of this that could go out. we could write books about it, and we still probably wouldn't settle it today.
That's why we have Miranda rights, your ability to have an attorney present during questioning, and you not say anything until your attorney shows up. I mean, that's a right.
When you were, anywhere between 5 and 15 years old, Jesse, would you turn around and invoke them? Would you realize how serious it was?
That's because I'm different. Yes, that's of course.
I realize that you were a child prodigy. You're an adult prodigy, Jesse, but I don't know. I mean,
no, Aaron, the truth is it's an important, whether you agree with anything in this case, whether you think Brendan Dassey did it or not, the idea of having a conversation, an understanding, a clarity about what tactics can be used and what cannot be used and what goes beyond the lines of constitutional or not, that's the key point here. That's what the law states. That's why we need some sort of cohesion, some sort of analysis here in the circuit. And like we said, there's a possibility this could go up to the Supreme Court. So either which way, I agree with you, Aaron, that this does need to be a conversation we need to have.
Everybody who watched the film, most of the people who watched the film have done a good job of digging into the case records, and that encourages me, because that's the kind of discussion we need to have. The film was a starting point for a conversation. It's not the ending point. And look, everybody who's following the film should be reading the Seventh Circuit's three-judge panel opinion that came out a couple of months ago. It's more than 100 pages long, but it's worth the read, because there's a two-judge majority and a one-judge dissent, and they both crystallize why this is a vexing issue. And when the full opinion comes out from this full court hearing that's going to start in a couple of minutes in Chicago, everybody who watched the film, who cares about the case, needs to read that opinion as well.
I want to talk about the opinion you just mentioned, because there's one issue we haven't had a chance to talk about yet. There is a statute called the AEDPA. It's the Anti-Terrorism and Effective Death Penalty Act of 1996. Why on earth am I talking about this? Well, it was brought up in this decision. The prosecutor is on the state side. They plan to argue that Dassey can't be given relief here because of this statute, because it sets specific deadlines on how long a defendant has to file a habeas corpus appeal. And what I'm going to read to you is basically what it says, is that even when a state court misapplies the Constitution, and here we're talking about maybe unconstitutional police tactics, a defendant cannot necessarily have his day in federal court. Instead, he must prove that the state court's decision was contrary to what the Supreme Court has determined is clearly established federal law, or that a decision was an unreasonable application of it. In other words, there's a really high standard here to even get into federal court from a state court decision. Now, Aaron, I don't know if you had a chance to look at the AEDPA or know its application here, but based upon what I've been saying, how do you think that applies in this case? And do you see it as a barrier for Brendan Dassey even getting his time in court?
Well, look, it is a barrier, and what could happen here is the majority of the judges on the Seventh Circuit could look at that, say that they think that it's good law, and just say that slams the door shut. Too bad, so sad. That is a possible way for the court to get rid of this matter without reaching the ultimate issue about juvenile confessions. And look, it turns it into a procedural game rather than a substantive game. And I would rather, at least just maybe for my own curiosity or for the sake of justice as it relates to Brendan Dassey, see the court bite into the bigger apple and not just nibble around the skin and go into the statute that you just mentioned, which has a long tongue twister name, and I'm glad that you spit it out because it's effectively a bar for defendants to try to have their cases heard. But look, I worked in an attorney general's office for a little while during law school, and there's a flip side of this. Part of the reason that we have these laws limiting these appeals is because everyone who's incarcerated is trying to find a way to get out. Mm-hmm. And they're constantly filing these things, and it bogs down offices of solicitors general, attorneys general, prosecutors, whoever has to answer them. There was one case that I was involved in where there was a prisoner who basically sued every single person in state government. And it took, I don't know how many hundreds and hundreds and hundreds and hundreds of man hours to deal with a case, including mine, of someone who pretty clearly was guilty of the sexual exploitation of children. And the evidence was pretty clear cut, and yet that person clearly wanted out. So not only did this prisoner sue everybody who was involved in the case, but the governor, the attorney general, the assistant attorney general, and then at one point, because they became a party to the lawsuit, the attorney general's office had to conflict out of the case. They had to hire outside counsel, and the thing just goes on and on. It gets expensive. And so some of these laws have been designed to limit those kind of shenanigans and to try to find a way for the courts to say, okay, look, we're going to look at this issue, we're not going to look at that issue, because states don't want to spend $20 million a year to deal with the onslaught of these claims.
Yeah.
Because for every good one that's out there, look, I mean, there are probably 100, 1,000, 10,000 bad ones. And
the law makes sense.
It makes sense for the courts to go through.
Right. It makes sense why we have it. And let it be known that the 3-judge panel actually felt that Brendan Dassey was justified under the law in bringing it under federal court, that he did meet that standard. But again, we're talking about, as you said, a full hearing in front of 12 judges. It might not be the same kind of result that we saw with that 3-court panel.
Go back into your reading of it again, Jesse. I mean, one of the things I think they're going to have to latch onto is whether it's a misreading of clearly established federal law. So part of what's going on here is, in order to get there, they're going to have to say that the standard that exists for juvenile confessions wasn't properly followed, and they're going to have to put the two together.
Yep.
There's a fear that if the court goes too far in laying down a new standard, then they're running afoul of the anti-terrorism and effective death penalty law.
Let's talk about that a little bit in terms of what a decision like this would mean, because one of the questions that we have is, if Dassey is successful in his appeal, if it sets new precedent down about what is the proper police tactics, what does it mean to have a coerced confession, one of the questions we have here, how would that affect, or in your mind, is there a case that you know of where, and look, we don't know what the retroactive effect of something like this would be, but just let's play a game here, for example. Is there a case that you've covered where there has been a juvenile confession and you said, you know what, I felt that if the standard were a bit different, that wouldn't have been, stood the day? Is there something maybe in your mind, a case that you've handled before, a case you've seen, where if the standard was a little bit different, and if we see that this is a coerced confession, and maybe you've seen something where there was being even more extreme tactics, that it might change the result?
Not other than this one, not off the top of my head that I can think of, because it's pretty rare. If we're to believe the prosecutor's line, hook, line, and sinker, and that's a big if, there aren't many cases that I can think of where an adult is accused of committing a heinous crime, where the adult then asks a teenage relative to sort of come along for the ride and then help.
Yeah, it's unique. It's unique. That's why it was a subject of Making a Murderer.
I mean, I'm sure that there's a case out there, and I know that even when I was in law school, 3 or 4 years before Making a Murderer came out, I remember checking off cases in my law school books, thinking that they were the sort of cases that could have application to the Brendan Dassey situation, and lo and behold, we're right in that area of law. So I mean, there is a little bit of precedent on it, but it's been a long time since I've reviewed it.
We've been talking so much about this confession. I think it's time that we show the viewers a little bit of that confession. So we actually have a short clip of some of Brendan Dassey's confession, or I should say confession. It's debating about what that's going to be debated right now. Was it a voluntary confession or not? So let's let the viewers decide in the meantime. So let's take a look at this clip, and we'll be back here with more analysis.
Brendan,
Go ahead.
what do you think is going to happen? What do you think should happen right now?
Oh.
You know, obviously, that we're police officers. Okay? And because of what you told us, we're going to have to arrest you. Did you kind of figure that was coming? For what you did, we can't let you go right now. The law will not let us. And so you're not going to be able to go home tonight. All right?
Does my mom know?
Your mom knows.
Your mom is here, okay? Would you like to talk to her?
Yeah.
Do you have it before we bring her in? Do you have any other questions right now? You do understand that you're under arrest now?
So could I call my girlfriend and tell her that I couldn't come today?
We'll give you an opportunity to do that. Okay? Did you kind of, I mean, honestly, after telling us what you told us, you kind of figured this was coming? Yeah?
Is it only for one day or?
We don't know that at this time. But let me tell you something, Brendan. You did the right thing. Okay? By being honest, you can at least sleep at night now, because I'm sure you had some difficulty with that. So you did the right thing here by telling us what happened. Okay? Just remember that in the future. Okay? You need to be honest.
Your cooperation and help with us is going to work in your favor. I can't say what it's going to do or where you're going to end up, but it's going to work in your favor. And we appreciate your continued cooperation. We talked to your mom about going out to the house and going in the house and getting a few items, and about you going out there with us and her and pointing out those areas that we wanted you to point out. Is that all right?
Do you know where those shoes are that you were wearing that day? Those red shoes?
I think they're in the closet.
Okay, what about the jacket?
In the closet.
All right, we'll have your mom come in for a few minutes, okay? All right.
Pretty Eastern.
Welcome back to Law News Network. I'm Jesse Weber. What you were just watching was the confession of Brendan Dassey. Brendan Dassey, who was one of the subjects of the widely popular Netflix program Making a Murderer. He was sentenced to life in prison in 2007 for the murder, rape of photographer Teresa Hallback. He was 16 when he told detectives that he helped his uncle, Stephen Avery, in this rape and killing in the Avery family junkyard. What is happening right now, as I speak, is a hearing, is arguments being made in front of the Seventh Circuit Court of Appeals. They're considering arguments over whether detectives use coercive and unconstitutional police tactics to trick Dassey into confessing and whether or not he should be let free. I was watching some of his confession. I'm about to show you the continuation of his confession and when his mom comes into the room. But in the meantime, I'm with Erin Keller, and right before Erin has to leave, Erin, you just show the viewers exactly what you showed me, because this is very key in this confession.
Well, this thing has been sitting on my bookshelf across the room. This is the motion, the memorandum that Stephen Avery's attorney, Jerry Buting, wrote up to try to deal with the issue of how Brendan Dassey's statements to police, which are on all the CDs that are still in the back of this, played a role in the Stephen Avery case. Because again, keep in mind, what Brendan said was never introduced in a court of law against his uncle Stephen Avery, but because the prosecutor spilled the beans and basically released the contents of the confession, everybody had heard about it in some way. And one of the issues with this, or what I think is the biggest issue in the case, is whether or not that's ethical. And in my opinion, it isn't in a moral sense, but it was legal. And that's the big problem here. You know, why did Stephen Avery go to prison? Was it because of what was said in court or what was said out of court? Well, the ethics laws allowed the prosecutor to basically say a lot in public about what's in this interrogation transcript and what's on these recordings, and it was in the back of everybody's mind when the case went to trial. But look, I mean, this is how this is the exact file that Stephen Avery's attorney, Jerry Buting, handed me outside the courthouse in 2007, and the filing of this was the first time the entire recording became public. Now these things are all over the place, but for a long time, the only places they existed were on these recordings in the courthouse. And a good percentage of this, it's about a 2-inch thick binder. And
light reading.
An inch of it is just the transcript of what was said. This is just the transcript of the recordings. So this is the guts of what they're arguing about in court right now. The rest of it is how Avery's attorneys thought that it poisoned the proceeding. So I have held on to this in so many of my other notes from the case all these years, and here we are 10 years later, and we're back to debating, in essence, the contents of what's in that binder.
You said it. It's a case that still hasn't gone out of the national headlines. It's still being debated, and as we talked about, just because there is a hearing today, we may see an appeal later on to the Supreme Court, and this conversation might still continue. But that's what we're going to have to look about later. In the meantime, Erin Keller, thank you so much for joining us today, talking a little bit about the Brendan Dassey case as well as the Morris Brothers trial, which we are going to be live streaming here at around 1:30 p.m. Eastern Time, so you're not going to want to miss that. Erin's been great here talking about the case, talking about the legal aspects of it. You're going to see him on later here, taking over this chair, talking more, hosting. But Erin, thank you so much for joining us this morning.
Yes, Jesse, good to see you again.
Great.